Добрий день, я вітаю всіх.
Good afternoon, my name is Yuliya Matviychuk and it's my pleasure to welcome all of you here in our discussion platform organized by Ukraine Media Center Ukrinform Brain Hub. Today is day 559 of the full-scale invasion of our homeland. It's been almost 10 years of the war, and now we will be talking about protection of those affected by this war. Gathering this studio are the representatives of human rights organizations who will present the roadmap describing what the parliament should do right now, what is the legislation to be adopted. So today is the first day of the 10th session of Verkhovna Rada of Ukraine, and our experts who deal with the rights of those affected by war will present this roadmap. Now, I want to introduce our speakers. They are Alyona Lunyova, Advocacy Manager at ZMINA Center. Joining us also is Yuliya Matviychuk, Advocacy Coordinator at VOSTOK SOS Charitable Foundation. Olga Skrypnyk, head of the Crimean Human Rights Group, and Rassamakhina, Advocacy Manager at Crimea-SOS NGO. Good afternoon, friends. Ms. Olga, let's start with you. Let's talk about this roadmap. What is the parliament supposed to adopt, in your opinion? Thank you, Ms. Olga. We want to thank the Ukraine Media Center, our permanent partner, who receives us with different events covering the problems of the people affected by the armed aggression. And today, present here are the representatives of coalitions of organizations dealing with the problems of those affected by the armed aggression, which was started in 2014. Our coalition, the human rights organizations which deal with this matter, starting from 2014 with the events that started in Crimea, in Donbass, and unfortunately the scale of the problems only increased since then. Our partners also deal with these issues starting from 2014, like VOSTOK SOS, Civil Holding, the Group of Influence, Stabilization Support, Crimea-SOS, and others. So we've gathered here today because the session of the parliament starts today. Today is the first day of the 10th session of Verkhovna Rada, which starts on this day, and it's important for us to draw attention of our people's deputies to the problems of our citizens. Unfortunately, millions of them still remain in the occupied territories, those who left the occupied territories, those who were forcibly displaced, and the scale of the problems of those affected people is absolutely horrific. But at the same time, we understand that our country can deal with the most of the problems in this area, and today we will focus on those draft laws that are either registered or which, in our opinion, need to be developed and adopted by the parliament to protect our people, both those who remain in the temporarily occupied territories, those who have become the victims of deportations, forceful displacement, specifically the children. So my colleagues will tell about the registered draft laws, among which are very important ones, in particular those covering the problems of civil conditions, civil statuses like birth of children in the temporarily occupied territories, the draft laws which cover the legislation on education, but there are those which still need to be worked on or rejected, because unfortunately even now we see among the legislative initiatives, among those which are important and can support the protection of those affected by the war, there are still draft laws of the populist nature, or they have no proper reasoning and justification, for example, feasibility justification. Also, we want to draw the attention of our people's deputies that those legislative initiatives and laws that are in effect and cover the protection of those affected by the war, they require budget financing. So it's important, considering the budget for the next year, to take into account all those expenses that correspond to the situation in effect. For example, we cover also the problems of civil hostages and prisoners of war, all those who are in Russia and in temporarily occupied territories. So those categories of people, they have right to the disbursements by the government, and unfortunately today the funding is insufficient, and we want to make sure that that amount of funds is contemplated in the budget that corresponds to the current condition of affairs. Those people, they really require mandatory funding from state budget, and we want to draw our legislators' attention to that. So talking about the role of the parliament, we think that our parliament may become, apart from being a legislative authority, for us as a civil society, it's an important platform for discussion, for search of mechanisms that will help us to do something to protect our people, that can be a synergy platform, so to say. But due to the martial law, our parliament is currently closed. I mean, the discussions are closed. We understand that it's a security matter, and we share all those concerns, but we understand that it's been almost 2 years of the full-scale invasion, and we understand that under conditions like this, there is opportunity to provide for more transparent and open operation of the parliament. So our coalition appeals to the parliament to make their work more open for the civil society, so that we could communicate all those issues and jointly find the mechanisms which can help. We see that we can bring back the agenda of the parliamentary committees, so we understand what are the draft laws to be considered. Yes, there may be exemptions to some draft laws that cover the issues of security and defense. They can be still closed, but we know that a lot of issues we see in those registered draft laws, they cover other issues which require involvement of civil organizations, the people whose issues will be covered by that legislation. And to make this discussion happen, it's important to bring back the agenda. It's important to provide for option of participation of civil organizations in the meetings of the parliamentary committees. So those are the recommendations that we are sure the parliament can fulfill, and it will provide for normal work for the parliament. And talking about the specific areas of this legislation, my colleagues will tell you more about that. There are zones, like the green zone, for example. The green zone is positively assessed by our coalition. The yellow zone says that the legislation is supposed to be, in our opinion, worked on more, and the red zone means that there are a lot of shortcomings in those draft laws, and they should be rejected, otherwise they could be of threat and rather than of use to our citizens. Thank you, Ms. Olga. Ms. Alyona, so let's proceed to discussion of those draft laws. Let's start with those that you marked green, those that you support and that should be, in your opinion, adopted by the parliament. Thank you. We try to communicate with the people's deputies on a regular basis, and we pay a lot of attention to those legislative initiatives that cover the issues of the population affected by the war, and we support that legislation that is supposed to support the reintegration of the citizens in temporarily occupied territories. Now that it's year 10 of the war already, we understand that there are issues, many issues that the the citizens of the temporarily occupied territories are facing. So the closer the occupation of territories is coming, the more urgent are the issues of those people who live there. Some of them live there for like 1 year and others for 9 years. And those draft laws cover the integration of those citizens in political and cultural life of Ukraine. One of such laws covers criminal and processual procedures and issues of covering trials, because many criminal proceedings were lost during the warfare, and there was a discussion in law enforcement agencies saying that we should make a procedure for the cases when the investigation is not possible due to the armed aggression of Russian Federation. Such a draft law is already developed, and it can deal with that issue, with the problems of the people who were condemned in temporarily occupied territories, so that they receive their punishment after the occupation. So we should take into account those facts that people continue staying in jails without legal grounds by Ukrainian authorities that condemned them back then. Two more draft laws cover more broad sphere. It deals with the problems of hundreds of thousands of people living there. It's about civil status. It's entering into marriages, death, and birth in the occupied territory. So the acts of civil status, they just confirm that people were either born or changed their marital status, or that they have died. And it's important for the Ukrainian citizens who live under occupation to receive those documents under extra court procedure. Unfortunately, now it's only done in the course that if a child is born in occupation, their parents should go to civil authorities. They will be forwarded to the court, and based on the court award, they can receive the paperwork on the civil status, which takes first a long time, and secondly, after the beginning of occupation, the way from the occupied territories is very long and expensive. So it's important for us to make sure this procedure of identification of facts that have taken place in occupation, to make sure this procedure comes into effect now and not after the occupation, because we will start training the employees of the civil offices, because after the occupation we may not have time for that. We will have to do something with hundreds of thousands of documents issued in occupation because we don't recognize them, and on the other hand our citizens will have no other paperwork to confirm those facts, like entering into marriages, birth of children, or death of citizens. Another draft law from that zone, it was supported by the parliament. Fortunately, now it's being worked on for the second reading. It implements the mechanism of attestation of knowledge obtained in the occupied territory. We understand that during occupation, specifically during lengthy occupation, we started in 2014, and we started from Crimea and Sevastopol, the children were obtaining education, more than 200,000 students. For us, it's important for the state to have the mechanism to attest the knowledge that was obtained by those children, so that as they become adults, they can continue their education, get employed in Ukraine. And such mechanism is supposed to be implemented by the draft law, and we expect it to be supported by the parliament. It's the matter of economic security, because when people cannot work with the documents issued in occupation, we don't recognize them, and there is no draft law that would propose to recognize them, but rather to implement the mechanism covering how we can use the data that are attested by those documents, and it's important for us to make sure that the number of such reintegration legislation grows. So there is not an extended number of registered draft laws on that topic, but it's important for us to have more and more of them, because the more of them we have, it means the more people's deputies believe in the occupation and the occupation of our currently temporarily occupied territories. Ms. Yuliya, let's talk about the other part of your presentation, the draft laws that are still need some elaboration. Well, the yellow, thank you for invitation. The yellow category are the important initiatives, but the draft laws should be still worked on due to these or those reasons. For example, the first draft law amends the status of the forcibly deported children. They are very important in the context of bringing our children back to Ukraine, but this draft law still needs elaboration in terms of coordination of terminology with International Criminal Court and Rome Statute to make those changes uniform, to make sure there is no miscoordination in terminology. Another draft law which is important in our opinion is a draft law that enables people to receive pensions in temporarily occupied territories. However, that draft law has some legal indefinition and uncertainty that may result in violation of human rights, because it does not contemplate the specifics of receiving such pensions due to restriction of access to the banking institutions, and it contemplates that people may receive pension only if they don't receive pension from Russian Federation. They should specify it, but in our opinion, such specification or such statement may have a discriminational nature, because people may not want to state about the obtaining of pensions from Russian Federation. Another draft law is 8201 that contemplates segregation of Article 17.1, the collaborationist activity, and segregates it from other adjacent crimes. It should be amended in Part 4, the exemption from criminal liability. It deals with the problems of those who were illegally mobilized in the temporarily occupied territories. And the last draft law in the yellow zone is the one that restricts the option for the internally displaced people in the module settlements. It's important to take into account the state policy on the adaptation and reintegration of internally displaced people and relieve the load on the state budget. In case of such people, Ms. Anna, we have another section, those draft laws that are supposed to be rejected. Why they are supposed to be rejected? Due to what criteria? Yes, thank you. So those in the red zone are the draft laws that we deem harmful. Formally, they are supposed to deal with the rights of internally displaced people, and the first of them is 8020. It contemplates the free or exemption from public transportation payments for all of the internally displaced persons. It's supposed to relieve the financial load, but I think that such amount of exemptions is exaggerated, because based on the wording of this law, the internally displaced persons may use the railway transportation and aviation transportation for free. Is it a really equal measure for the rights of internally displaced person? In our opinion, it's not so, because it will it will result in the necessity for the development of procedure or a mechanism for reimbursement by the budget funds to the transportation company. And do really the internally displaced persons need such an amount of exemptions? This law can be only categorized as one of populist nature and eventually may result in harmful consequences. We know what are the financial obligations of Ukraine for the time being, what is the amount of financial assistance that we get from our partners, and an adoption of this draft law will absolutely result in increase of that amount of the financial assistance Ukraine will require. In the same category falls draft law 6301, the one that amends the law of Ukraine on court fees, and it exempts the internally displaced persons of such fees. And it says that the internally displaced persons are exempt not only from those fees that are paid during the consideration of their status as internally displaced persons. So in that case, people who have the certificate of internally displaced persons, they can use court authorities with any cases without paying any fees. So again, here we should pay attention to the load on the judicial system, and to remember that generally the judicial system goes the justified way to relieve the workload, and this draft law basically encourages all the internally displaced people to go to the courts for any reasons. So if we analyze those draft laws on the exemption from the transportation fees and exemption from the court fees, I would talk about the positive discrimination. So one group of population will end up in better condition compared to the others. Another draft law is 9279 on compensation for the victims of the armed aggression by Russian Federation. This draft law implements the system for distribution of future reparations, which are supposed to be received by the aggressor state in future and are supposed to be distributed among the victims of aggression. At the same time, this draft law categorizes all the Ukrainian citizens as victims of armed aggression. The problem is that it declares the standards, but at the same time there are no legal relations that it describes. Obviously, the compensation from the aggressor state is of urgent nature, and one day it will require some special standards, but this issue should be approached in a different way, because we know that to obtain the compensation, very complicated solutions are necessary, very complex legislative regulations and mechanisms that should be coordinated with the legislation of, for example, European Union, because the majority of confiscation assets of Russian Federation for the time being is located in the European Union countries, and it's a long way that is still due for us. And during the war 2023, in the fire of the war, to adopt the legislation that declares that Ukraine is supposed to compensate all the expenses and damages to the people of Ukraine is a little bit premature. This draft law, in case of its adoption, will not cover any practical costs. It's of populist nature, because in case it is adopted, the parliament may report that they do everything for the compensation of those affected by the war, but in our opinion it's not. In no way it brings the compensation closer for the citizens of Ukraine. So that's the list of the draft laws that we deem irrelevant for the time being, and we propose to have them rejected. Thank you very much, dear colleagues. You've done a tremendous job. And I have a question to all of you. What your actions will be to make sure that the roadmap you've prepared is heard not only by our legislators, but also taken into account by them. Let me start for us. It's important to make sure that the people's deputies start their work, that the parliament opens its work, makes it transparent in part of the development of the draft law, because some of them are in contradiction with the government policy implemented in the country. For, like my colleague said, those that are in the red zone that will stimulate the people to obtain their internal displacement persons, because some exemptions are not justified, for example, there. So we keep the people's deputies on a regular basis as we prepare such roadmaps, and we disseminate it among the people's deputies, among all of them. Their contacts are not in the website, but we search and find them. So in our opinion, those contact details should be returned to the websites so that civil organizations can contact the government. And we continue working with the government, and some of those draft laws were developed together with the civil organizations, specifically those about the civil status of the citizens. So I hope that we will continue this partnership with our people's deputies that existed before the full-scale invasion, and we want to bring back that form of cooperation to make sure that we develop a good agenda for our country, a proper agenda. If I may add just a couple of words, one of the instruments available to us and that has proven their effectiveness is the war cooperation with our international partners. Many countries, as it's known, they support Ukraine, and there are big NGOs and government organizations like European Union and the Council of European Union which assist and support us, but at the same time they monitor, and it's important for them to understand what Ukraine does in their internal policy, because to make it sound simple, they want to know how effective and how transparent are those funds that they allocate to Ukraine are used. For them, it's important to understand what draft laws are either adopted or about to be adopted. My colleagues mentioned the law on collaborationism. That will be one of the key problems, covering the problems of reintegration. And during international meetings, during Crimean platform, for example, we are being permanently asked, what exactly is Ukraine going to do? Is Ukraine ready to go that way that will help people to reintegrate rather than create some obstacles in communication? So we can do some of the things beforehand, which means that the work with such institutions as European Union or European Council is effective. They meet our people's deputies on a frequent basis. They have more opportunities to communicate with them rather than with us, because unfortunately we don't always have access to our people's deputies, and the European deputies, they address us asking what is the analysis that we have of the legislation that is about to be adopted. As Alyona said, we work for a number of years, so we enjoy certain trust, and we can act through our partners who usually support us and communicate with the people's deputies. And there are platforms that prove to be effective for us. For example, the second parliamentary summit of Crimean platform that is about to take place in Prague. Our parliamentaries will be there, and they will be meeting all the deputies who support Crimean platform, more than 60 countries. And for us, as the experts of the civil society, it's one of the platforms where we can talk to our partners, including our people's deputies. Sometimes it happens so that that is the only place we can meet them and talk to them and to promote our roadmap. I want to thank you again. If you have anything to add, please, the floor is yours. Well, my colleagues were telling about the practical steps on implementation of this roadmap, I would like to add that it's desirable for the Parliament to realize one thing: reintegration processes are not the choice of Parliament. It's not like they are to choose whether to take care of reintegration and the occupation, but those processes are imminent, and the earlier we start developing those complex mechanisms, the better. They should have started not even yesterday, but even before, but even today it's not too late yet, and they rather start doing that than adopting any populistic laws. Well, but after we've seen those draft laws that you categorize as green ones, so how much work is still left in the legislative sector to deal with the issues of the people affected by the war? So what do we have ahead? How many more such legislative acts are supposed to be adopted? Well, we should talk more systemically about what Ola has said regarding the law of liability, bringing to liability for collaborationism. So people who compromise themselves in collaboration, those who fall under the effect of the law on collaboration, we should understand that the judicial system of Ukraine will not be able to bring all of them to criminal liability. And another issue is to verify how possible it is. So it's important for us to make sure that those who were epitomizing the occupation are brought to liability. But for the people who did not support the occupation seriously, it should not be in effect. And again, there will be a lot of issues regarding the documents issued in the occupation, and that issue should be solved too. Okay, we don't recognize any of those documents, but practically what are we supposed to do after the occupation of Crimea? There were a lot of legal transactions, and we cannot act like they never happened. We don't have this procedure. We don't know what would be the next step. And in the same way, we should continue talking about the citizens of Russian Federation that inhabitate the temporarily occupied territories. Somewhere it's hundreds of thousands of them, somewhere, thanks God, not so much, but we should talk to our international partners and discuss how we will deal with the citizens of Russian Federation. We will take the position that those who came in illegally should not stay in those territories, but the mechanisms should be in place to remove them or to retain them there. And it's important for us, as for the country, our government should start working on that right now. Well, the question is that almost all the initiatives that deal with the justice is a very lengthy and a complex work. It's a very painful and sensitive discussion for our society. The scale of such problems is really immense. All the matters of compensation, of reestablishment of law and order, it's always a very complicated question. What to do with our citizens that were under occupation? What scale of access will they have, for example, for the work in public governance? How will we reestablish the governments there? And another complicated matter concerning both legislative work and other spheres is the mitigation of consequences of the occupation in such a mental sense, since it will be 10 years as some people spent in occupation. How will we reestablishing those processes? How to deal with the children who were living in occupation? And another human rights issue here, which is unsolved for many years, is to make sure that our legislation is coordinated with the international humanitarian law, that it's in compliance with international humanitarian law. We want the war criminals to be persecuted, but we have not ratified the Rome Statute yet. So it all should be in compliance with the standards. We cannot make sure that we take part of the MGP here and something from here, from international humanitarian law. It's not like we do it for International Criminal Court or somebody. We do it for ourselves, because the majority of the crimes committed by the Russians will be investigated by our judicial system. No court, no prosecutors will come from other countries. They will only prosecute some high-level officials. All those terrible things happening in Ukraine will be investigated by our judicial system, and they should be doing it with a high-quality approach, so no one could blame us that the investigation is biased or something like that. So we should harmonize our legislation with European legislation, and because it's not yet solved, because the crimes are supposed to be investigated now, not later. Well, some of those questions are very, very complicated and sensitive for our society. I want to thank our speakers. I want to thank everybody attending. I want to thank our armed forces. Let's continue working for our victory. Glory to Ukraine.